Welcome to the Buck Stops here. I'm Barkha Dutt. On the program this evening, a watershed moment for India as the Supreme Court upholds the constitutional validity of the Right to Education Act. However, will this mean an interference in the autonomy of schools, as several petitioners in the case argued? Their argument was not accepted by the Supreme Court, but that is the defining image of India today. A day on which the Supreme Court has said that every child in this country is entitled to free and compulsory education. It also means that schools, including unaided private schools, will have to reserve 25% seats for poorer children. How will this work really on the ground? And what about the fears that schools are expressing on the extra costs? All these are some of the issues that we're looking at on the program today. All right, before we're joined by Minister Kapil Sibal, my colleague A. Vaidyanathan has been tracking that story in the court. And Vaidya, we know that the Supreme Court today, there was of course one dissenting judge, but other than that, the Supreme Court bench headed by the Chief Justice himself said this was an issue that had to be looked at from the point of view of the child, not the point of view of the school. In effect, rejecting the fears expressed by private schools that this was an infringement on their autonomy. What were the key highlights of the judgment today, Vaidya?
Barkha, before going into his judgment, for the past 2-3 months, government is very upset, saying that court is interfering in the policies of the government. But this judgment, Mr. Kapil Sibal as well as the government would be happy to look at it. So basically, the Chief Justice today made it one important point, saying that this Right to Education Act is child-specific, not institution-specific. That is one of the greatest points. The judgment also goes on to say if a child is denied access to education, it not only, deprived of the freedom of speech and also right to live with dignity. These are very important points, but as you rightly said, the private schools argued, saying that the court is interfering with and violating the right given by the Supreme Court. But here in this judgment, it's clearly stated, saying that this right to education, particularly for poor children, overrides the right to freedom exercised by these private schools. So as we also said, that one of the dissenting voice, that dissenting voice is on only one issue. The Right to Education Act is constitutionally valid. The dissenting judge, Justice K. Radhakrishnan, also held that. But one point which he dissented was, he said that this minority as well as the private schools, it should not be applied because it's the duty of the state to give free education. Why are you involving the private schools?
That's right. We do have to underline that this particular Right to Education Act does exempt boarding schools and unaided minority institutions, Vaidya. And is there any chance that the schools will now file a review petition, or are they willing now to accept this judgment as final?
I think most of the schools will be willing to accept this judgment as a final, because already Act is there, and then Supreme Court has also delivered the judgment. But as a legal exercise, they may go in for review, which may mostly 99% of all the reviews are likely to be rejected. So they may take this step, but this judgment is almost final.
A. Vaidyanathan, thank you for bringing us up to speed on those details on the buck stops here. Of course, the big question is whether the opposition expressed by some private schools who receive no grants or aid from the government, is this opposition elitist? But before we come to our debate on the program this evening, let's speak directly to the HRD Minister himself, Kapil Sibal. We spoke to him earlier as a newsmaker on the program tonight. Now, Kapil Sibal, it's obviously a watershed day. It's a watershed legislation that has been upheld by the highest court of the land. What for you is the main important takeaway today?
I think the most important takeaway is the fact that the Supreme Court has said that when you look at education, education is an enterprise, education is a mission which is child-centric. It's not institution-centric. So when you look at education, you should be looking at what children need, what children require, what children want, what is the future of children, not what is the future of the institution. The institution only provides a mechanism through which children realize themselves. And I think that interpretation of the court is perhaps central to education and to our vision as we move forward as a country.
But Kapil Sibal, as you're well aware, and which is why this matter was in court to begin with, a number of unaided private schools, that are schools that have absolutely no benefits or grants or even subsidized land from the government, are questioning certain aspects of this act. They're saying this is an infringement on their autonomy, this is an infringement to decide how they should run their schools, and they're arguing that the best universities, the best schools in the world, Oxford and Harvard, don't have governments of their country telling them how to run their schools.
Who is asking them how to run the institution? They are entitled to run the institution the way they want. The only thing that we have said is that 25% of the children in class 1, in year 1, must be of the disadvantaged sections of the community. How is that interfering in the autonomy of the institution? And again, you are asking me a question which is institution-centric. Remember, the court has said your question should be child-centric.
But Kapil, yes, I do take that point, but we do have to keep in mind that many of these schools are arguing that they will effectively be depleted in resources. There continues to be a degree of ambiguity as to what amount the state will pay to compensate or to provide for the education of the poorer students, the 25% who will now get to study at all of these schools. Could you please set the record straight on that? What will be the amount of reimbursement from the state, that's the Indian state, centre or state government, to these private schools now?
You know, Barkha, it is set out in the Act itself. If people care to read the Act, you will find what is set out. And this was argued at length in the Supreme Court by the private institutions and has been rejected by the court. So the assumption has to be that the provisions in the Act in respect of 25% reservation in private unaided schools is a reasonable provision, and therefore this has to be taken forward. I mean, I am not running the institution, but the fact of the matter is that these arguments were made before the court and the court has rejected them. There is no point having a television channel debate on an argument that has been rejected by the court.
It's been rejected, but there still remain some questions, Kapil, and one of the other questions is what happens to government schools. And some critics have said that this is an example of the state outsourcing its responsibility on improving government schools. Now, obviously, nobody, even in the poorer sections of society, is going to want to send their children to government schools as the first choice. So the fear is that the quality of government schools will decline even further.
Oh, absolutely not. This is completely wrong. You know that if you look at elementary education, by and large about more than 85% of schools are government schools. So where's the question of a decline in government institutions because 25% in class 1 in private schools are going to belong to the disadvantaged section of the community? I think this is a non sequitur. I mean, an argument has no basis.
Do you have the NDTV Profit app? All the markets, all the news and your own homemade, ready-made portfolio available there for you.
We will right now answer what you should sell, what you should buy when markets are down.
Download it ndtvprofit.com/apps. Get the best app from the channel you trust.